Welcome back to the Tech Talks Daily podcast, where I'm at Web Summit in Lisbon. And today I'm excited for the opportunity to sit down with a true expert in the intersection of law, technology, and media. His name is Ed Claris, and he's the managing partner at Claris Law. And Ed brings with him a wealth of experience from his 17-year tenure at powerhouse brands from ABC and Disney to the New Yorker and so many others. But today we find ourselves at the show floor at Web Summit and also at a pivotal moment in the digital landscape. So my guest today is speaking on a panel titled AI versus IP. He's going to be talking with Dan Milmo of The Guardian and diving into the future of copyrightable content in an era where artificial intelligence is no longer just a distant concept, but a tool being rapidly embraced by Hollywood studios and media giants. So together, we're going to explore the real-world implications of AI on intellectual property rights and also the challenges that it presents, both to creators and legal professionals. So what does the future hold for copyright law as AI shapes the boundaries of creativity and ownership? Well, let's find out. So a massive warm welcome to the show. Can you tell everyone listening a little about who you are and what you do?
Sure. Thanks for having me, Neil. I'm Edward Claris. I am a lawyer based out of New York, where I practice intellectual property as it relates to artificial intelligence and as it just relates to itself. I represent media companies, movie, television, podcasters, documentary filmmakers, digital media companies.
Fantastic. Well, it's a pleasure having you on the podcast here at Web Summit. And of course, AI-generated content is rapidly gaining traction in media and Hollywood. So from your perspective, what are the biggest legal challenges that this technology poses to existing copyright frameworks? Because IP and AI is a topic that's increasing, isn't it, at the moment?
It is. It takes up a lot of my day. There's some huge issues that are happening. More and more content's being created through AI. What is created by? It means that there's algorithms that have been trained on lots of other pre-existing content, and those algorithms are capable of outputting pretty much whatever you'd like: audiovisual content, audio content, textual content, illustrations. And so the question is, how does it get created? Training data, for sure, but also prompting by human beings. And some prompting can occur through hundreds or even thousands of prompts, and it can happen in iterations. So you can have an evolving piece of content that comes out. That what one might say is a tool, where they're using it almost like a PowerPoint presentation or as a computer-generated graphics, CGI. There's a lot of different ways to use the generative AI, and people are getting better and better at it. So Hollywood is trying to figure out what it means, and there are a lot of legal issues. There's questions around authorship. If the generative AI creates the content itself, has it been authored by a human being? A pre-existing requirement in order to have authorship. Pretty much every country in the world, whether it's China, Japan, Australia, UK, EU, US, all require some human input. But they're all coming out a little bit differently in terms of how much human input. Some countries have said that prompting alone is adequate for authorship. Others are saying that prompting is not adequate. The US, for example. The US has taken a pretty strict rule that generative AI does not have authorship human being and therefore no copyright. Whereas in China, for example, and the EU and the UK, there's more permissiveness around what prompting means and whether there's authorship. And then there's questions around infringement, the training data, and whether the training data has been taken without permission and used to create new content. And so we're seeing a world where there's a lot of potential litigation and controversy around what AI will mean for Hollywood and other content creators.
Yeah, it is such a big topic right now, especially with the increasing adoption of AI by studios and media companies. And so with all that in mind, how do you see the role of traditional intellectual property laws evolving to meet this new requirement? And Are current copyright laws equipped to handle the complexities of AI-generated works, or do you think a legal overhaul is almost necessary?
Well, we've had anxiety since the early days of technology. It used to be obviously that everybody would create content through the quill and then the pen and the pencil, and then it went to the camera and photography. And in the late 1800s, there was a case that went up to the Supreme Court of the United States where people worried that cameras would get in the way of real content creators, and that any photograph would sort of commandeer the whole space for visual artists, for example. And the Supreme Court said that even though a machine was being used with a camera, it was still the party who was controlling the camera, the machine, was the author of the work, and that would be a copyrightable work. So from there, we've seen lots of technology come in the way of content creation. There's video cameras, and there's all sorts of technology that's used every day. There's animation technology. It used to be that when you saw Mickey Mouse, every single frame was drawn. Now the frames are drawn once, and then the rest of the frames are created by the computer. Those are well-established, well-accepted uses of technology to create content that's copyrightable. Do we need an overhaul now that we have AI? Potentially. There is this renewed anxiety around whether AI is going to, commandeer the space, just like the camera in the late 1800s. There is this worry that we will no longer be creating creative content. And then there are other people who are thinking that AI is going to be a great partner and will give us the opportunity to think of all sorts of new ways to make content that is copyrightable and is enjoyable and is ultimately owned by a human being. So I think it really depends on who you are and whether you're anxious made by technology or you feel like technology is an opportunity.
100%. And of course, there is an ongoing debate about whether AI-generated content can be considered authored and thus copyrightable. So where do you stand on this issue, and what implications does it have for both the creators and the content owners?
Well, I believe that anybody who gets involved with creating content as a partner with AI should be the author. That would be my personal opinion. There are those who believe that more than just prompting is needed in order for authorship to accrue to the individual. But I think that if we disincentivize people from using the technology, we're going to be losing a great opportunity to have this tool, which will create new works in conjunction with human beings. Now, certainly there are some solutions out there where the content is just generated without any human input and is put out immediately into the internet. That's the exception to the rule. Generally what's going on is that everybody in Hollywood and media are using them as tools, and therefore they're being more productive. They're being a little bit more creative because they have lots of more ideation going on. And I think that that's a great opportunity, and we shouldn't disincentivize the partnership with the technology.
And of course, we're here talking at Web Summit in Lisbon, and given your extensive experience with media giants from ABC and Disney to the New Yorker, I'm curious, from everything that you're seeing, what shifts are you seeing in how major studios are approaching AI in content production, especially regarding rights management, licensing, and all those big topics too?
It's actually a really difficult question. I currently represent over 300 media companies. I did work at some of the largest ones in the world, and they're having some difficulty because if what they create using AI as a tool is not protected by copyright and therefore cannot be monetized over a long period of time without falling into the public domain, they're worried about using it. So some people are using it and not telling anybody. The Copyright Office says that you need to certify what component of your content was created by AI versus what was created by human input. And you're supposed to come clean with the U.S. Copyright Office. That's going on also in other countries as well. So what companies are doing is largely either not talking about what they're using or when they are talking about it, they're trying to come up with new solutions for how to license their content and monetize it. Yeah. For example, there's the blockchain. Blockchain is a way to control licensing of content without necessarily copyright. It would be through another technology of encryption. And I think that this new world of AI and unprotected or public domain content may well be served and be solved by new licensing schemes, including through blockchain.
And I think we need to remind everyone listening that generative AI tools are often trained on vast amounts of existing creative content, which raises concerns about unauthorized use. We've also heard Sam Altman, I think he was talking about if it's on the internet, it's fair game. Apple allegedly accused of scraping data from YouTube, etc. So how should companies navigate the legal risks associated with using copyrighted material for training AI training data sets? Because at the moment it seems it's okay, but it almost feels like in the future this one could come back to haunt some of these companies.
Yeah, well, there's a bunch of lawsuits in the United States and around the world that are challenging the scraping and using of other people's copyrighted material to train AI. In the U.S., which is where I focus, there are a couple of cases that courts have already decided where it looks like using content in training is not going to be copyright infringement. And largely the fair use doctrine, which we have in the States, is a way for companies to, on the one hand, respect IP, and on the other hand, use IP for new and transformative purposes. Whereas in other countries, the fair use doctrine really doesn't apply, and strict copyright rules do. So we've found that in the United States, at least, there's been a lot of technological development. All of the AI companies have pretty much come out of the States, and largely one could say that's because there's permissiveness. And on the other hand, those who want the status quo are concerned and they're suing, and they don't want their content taken without their permission and without payment. There are some situations where the AI companies are now licensing and paying a lot of money to companies. There was this word that Fox got $250 million for a license to give over their audiovisual content. But many others are not being paid and are suing, including the New York Times, for example, which has a huge lawsuit against OpenAI and Microsoft for illicitly taking their content. So we can see that there's a multiplicity of ways to go about this, and the courts in the U.S. and other countries will have to solve this very sticky problem, protecting human input and human authorship, but at the same time endorsing technology.
For many media and entertainment companies, the promise of AI is balanced by fears of legal disputes in the future, especially over ownership and copyright infringement. So for anyone listening anywhere in the world, what would you say are the best practices that you'd recommend to businesses maybe looking to leverage AI while also mitigating potential legal pitfalls in the future? Good question.
I oftentimes give advice to my clients that they should use AI for sure as a tool. They don't need to advertise that they're using it. It's another piece of technology. We all use Microsoft and we use, all sorts of tools, and we don't necessarily advertise that. We just have it help us create as a partner, as a tool. And I think that people need to get good at it. Prompting, the art and science of prompting is something that comes with time. And I find that even in my legal practice, I'm practicing using the AI tools in order to help me with some brainstorming on solutions. Oftentimes what I'll do is I will come up with an idea, write out my whole strategy for a client. Could be many different parts. And then what I'll do is I'll have the AI answer the same kind of question that I've already done, just to see if I've missed anything, and also to see what my client might be looking for in the AI. There may be a day when they're better at prompting an AI to give them legal advice than they are at coming to me. So I want to make sure that I'm anticipating what the AI is going to tell them.
And as businesses increasingly turn to AI for things like code generation, how important is private AI? And do you think that resolves any potential IP implications from integrating AI-generated code within their proprietary products and applications? Because this is a question that I'm getting asked more and more lately.
Yeah, that's a good question. There are two different ways that you look at training data. One is through a large language model where there's a huge amount of content coming in from many different sources, as we said, scraped from the world. And then there's also more proprietary AI language models that are just trained on things like your own emails and your own documents and internal corporate material that you're providing to the AI in a closed environment. And places like Microsoft have come out with a product called Pilot, and they're making some promises that the content that you put into their solution, when it's on the private side, is secure and not going outside the firewall. I think that that's probably something that we can rely on. Microsoft is a very good company, and they're pretty good at security. But be careful, because you don't know who you're partnering with. And if you are providing content that could potentially get out, that would be a breach of your own client's privacy or your own privacy. And the lack of security would be really problematic.
And you're someone who teaches media law and intellectual property. So I've got to ask, how are you preparing the next generation of lawyers to tackle some of the unique challenges that AI presents in these fields? And are there any key legal precedents or cases that you think will possibly shape the future of AI and copyright?
Well, my students are all probably ahead of me in terms of their ability to play with the tools. They're all helping. They're using the tools to help them write papers and come up with ideas. I have young associates who also use AI to help them be better lawyers. So largely it's making sure that they understand the base principles of copyright and IP, making sure that there's an appreciation for what is owned and what is shared, and understanding how technology has been used by courts as a way to both advance the law and also protect against inappropriate behavior. And so I oftentimes look at balancing different interests with my students and have them be sensitized to both points of view so that they go into the world with those in mind.
Well, I know how incredibly busy you are, and you're going on stage tomorrow, I believe, here at Web Summit. But for anyone listening, maybe they want to reach out and find out more information about the kind of work that you're doing, dig a little bit deeper on this topic. Is there any way you'd like to point everyone listening?
Sure. Edward Claris, I'm on LinkedIn. Always reach out there. I'm on LinkedIn often. My law firm is clarislaw.com, and come visit, get in touch. Happy to talk.
Well, I'll add links to everything so people can find you nice and easy. But thank you for stopping by, and best of luck in your keynote tomorrow.
Thank you, Neil.
I think it's clear from our conversation today with Ed that the rapid adoption of AI in media and entertainment isn't just about reshaping business models. It's also about challenging the very fabric of intellectual property law. And Ed's insights highlight both the opportunities and the legal complexities that we need to navigate as AI-generated content becomes the new norm. And as we look ahead, the key question remains, how will the legal system evolve to protect creativity while embracing innovation? So much food for thought there here on the show floor at Web Summit in Lisbon. But wherever you're listening to this conversation today, wherever you are in the world, let me know your thoughts. Please email me, techblogwriter@outlook.com, LinkedIn, Instagram, and X, just at Neil C. Hughes. Let me know your thoughts, and I'll be back again tomorrow with another conversation here at Web Summit. But enough from me. Time for me to look for some free tech swag. So I will speak with you all again tomorrow. Bye for now.